Okay, thank you all for bearing with us. We got our equipment problem straightened out. Took a little longer than we anticipated, so I appreciate you.
Maybe seated, everyone.
Defense, call your next witness, please.
Let's call Eriese Tisdale.
Thank you for bearing with us. Let me just have you watch those wires here. Should place you under oath.
Do you swear?
Place you under oath.
Do you swear from the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Just watch stepping in, man.
Can you please tell the jury your name and spell your last name for the record?
Charmaine Tisdale, Tisdale.
And how do you know Eriese Tisdale?
That's
He Erise's son?
yes, he is.
Now, have you been to the jail to see Eriese?
Several times.
How often do you go to the jail?
Normally every Monday.
Every Monday. And do you take Zamir with you?
Occasionally, yes, I do.
Okay. What does Zamir call Eriese?
Dada.
And does he get excited when he sees Eriese?
Yes, he does.
And do you talk to him about his daddy?
Yes, I do.
During the visits that you have with your son and your grandson, what are some of the things that you all do together?
Well, Zamir enjoys music. He likes to play the drums. And he likes the rhythm of the ABCs. So that's something that him and Eriese share together.
And does Zamir recognize Eriese?
Yes, he does.
Do you show him pictures of him?
Yes, I do.
As well as him being able to see him on the video?
That's correct, yes.
Judge, may I play the video now?
I have her identify the exhibit. Unless the state doesn't object, but she needs to identify the exhibit. I mean, it's...
Yeah, we're not objecting.
Okay. The objection be admitted as, has it been identified yet? Is it, what's the next defense exhibit? It has to be identified. Defense Exhibit 26. Without objection, go ahead and admit it, and you may publish it if you wish.
Hey, what's up? What's up? Hey, boy, what's up? Daddy love you. Say Dada. Say, what's up, say? Say. Hey, what's up? What's up? You be a good one? Huh? Hey, what's up? Hey, I love you. What's up? Hey, what's up? Look at like you there. What's up? What's up? Hey, what's up? What you doing? What you doing? Huh? What you doing? Stop, baby. Stop.
believe Zamir may have been about 1.
How old is Zamir in this video?
Maybe close to about 1 years of age. A handful, as you can see.
Zay, what's up, Zamir? Zamir, what's up? What's up? What's up? Say, Dada? Hey! Hey! Say, Dada? Huh? Hey! Say something. Dada? Huh? What you looking at? What you looking at? What you looking at? Huh? Huh? What's up? What's up? What you doing? Hey! Hey! Huh? What's up? Are you ABC? You know your ABCs? A, B, C, D, E, F, G. H, I, J, K, L, M, N, O, P. That's that! Yeah! Yeah! That's that! Say, come on, say! Hey, you want it? Hey, you got the phone? Hey, there you go.
You had to watch that phone.
Hold that phone. Hold the phone. There you go. Hey, like that. Hold it. There you go. Like that. A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y, and Z. Hey! A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y, and Z. Now I know my ABC. Next time, won't you sing with me? Yay!
How old is Zamir now?
Now Zamir is about 2.5 years of age.
And so how is the interaction now with his father?
It has increased. You know, he's talking a little bit more. He's communicating a little bit better.
That's all I have.
State wish to inquire?
No, sir.
Thank you very much, Ms. Tisdale. You just step down. Step it down for me, please.
I don't check, I don't.
Let's call our next witness, please.
You're on defense.
Sorry?
The defense rests.
Yeah, go approach, please. your attention. I'm going to let you go home now, or go wherever you wish. Please don't discuss the case among yourselves, or allow anyone to discuss it in your presence, or fix any opinions as to the merits of the case. If I can have y'all come back at 8:45 tomorrow morning, your jury assembly room, we'll bring y'all in. Okay? Thank you very much. Get your patience. Jury's been excused. Ms. Miranda, we need whatever the device was that was used to play the video so we can make it a part of the record.
Yeah, what we'll do is we've got both on the CD and a thumb drive, and we'll just, the clerk's okay with it.
Okay, as long as that exhibit's preserved in the record here. So if you want to give it to the clerk.
Certainly.
It's a CD, the flash drive is whatever one. You can have a seat, folks. That's perfect, better.
Yeah. That's why I put the CD originally, because I thought it was going to be easier for you.
Okay. Now, when the jury comes back in the morning, I'll just have this state announce they don't have any additional evidence, and then so the jury's clear on that. Mr. Packardall, did y'all email these instructions to Alice, or can you, or email them here so we can look at them?
I will. I'm going to send them to the clerk, but would you like me to send them to Alice too?
Yeah, because she can, I think, once we get them finished, she can make copies a lot quicker. She just sends them to the copying machine, so.
What's Alice's email?
crumpa@circuit19.org, I think.
Leslie, you forward it to her just in case it doesn't go through. And I'm sending it to Miss Saldonia and Mr.
I'll step off and make sure she gets it. So when all this is done, I'll come right back. I promise. Nobody needs to get up. Nobody needs to get up. counsel present, defendant's present, the jury is not. All right, how much time are y'all requesting for closing argument? Just
An hour.
defense?
Hour and a half.
Each side will be afforded a total of an hour and a half. My understanding is in the penalty phase proceeding, the state goes first, followed by the defense, and then that's it.
Yes, sir.
Okay? All right. If y'all want any time warning, let Miss Leslie know. She'll be happy to warn you. Okay. After y'all are finished, I'll read the penalty proceeding in capital cases instruction as proposed here. Does the state have any objection to that being read?
No, sir.
Defense?
No, Your Honor.
Okay. I'll read weighing the evidence, the first two paragraphs, and I think all 7 as designated are.
Excuse me, I deleted some, so you guys might want to look and just make sure that nobody
Okay.
can apply.
Okay, let me look.
I think there's 10 of them, so. I don't think we had any felons testify in the penalty phase. I don't think we had the evidence of reputation.
Wasn't Mr. The one fellow,
Who?
the fellow with the dreads? I
He
can't
was
remember.
not a felon.
He was. Okay, he was not a felon.
He was not a
I
convicted
remember
felon.
there's some conversation about it, he's not.
No, he is not.
Okay.
We were talking about the Brejan, Uncle Brejan that died. He was a convicted felon.
Right.
I'm sorry, I can't remember the gentleman's name.
Ahmad, that's fine.
Yeah, that's right. Okay, so 9 and 10 are not applicable. But the others appear to me to be okay. Defense have any objections to the weighing the evidence proposed instruction?
I took, the other one that's taken out is any pressure or threat. I don't think so, just so you know, all the 3 of them that are out.
That's fine.
Okay.
I agree.
All right.
I'll read the fact that a witness is employed in law enforcement does not mean his or her testimony deserves more or less consideration. Was there a law enforcement witness in the penalty phase?
I put that in there only because of the Sheriff Mascara's victim impact, but if you want it out, I'll...
I would take it out because I'm going to instruct them on victim impact, and I don't think there was any other law enforcement testimony.
Fine, that's out.
Defense agree with that?
Yes, sir.
I think obviously expert witness instruction is necessary. State have any objection to that?
No.
Defense?
No.
Now, there's instruction about the defendant not testifying, as Mr. Tisdale's elected not to, so
Yes.
assuming the defense is requesting that, I'm obligated to give it.
Yes, sir.
State have any objection?
No.
So I'll, of course, omit the instruction about if the defendant testified. Now, if y'all can just take out that bold part where it says give only if the defendant did not testify. That's just a note to the judge. I think rules for deliberation in its entirety is necessary. State have any objection to that being read?
No, sir.
Defense?
No objection.
State have any objection to the aggravating circumstances instruction?
I'm sorry.
Do y'all have any objection to the aggravating circumstances instruction?
No, Your Honor.
State.
Can't hear you.
Do you have any objection to the aggravating circumstances instruction?
No, I don't.
Defense?
No, Your Honor.
I'm sorry, you skipped rules for deliberation.
Oh,
You didn't?
maybe I didn't hear you. I did ask about it. Do y'all state have any objection to it being read?
No. Okay.
All right, now, the state's proposed 4 aggravating circumstances for the jury to consider. Does the defense have any objection to those 4 aggravators being provided?
No, Judge, we see the doubling instruction is there,
Yeah.
so we're fine.
Take a look at the, obviously there's the standard doubling instruction, but then the note requires you to identify for the jury what doubles.
So I created that language so if everybody would just read it and make sure they don't have a problem with it. It starts the aggravating circumstances which double one another. Excuse me.
Okay. Appears appropriate to me. Defense.
Yes, sir, it's fine.
Okay. I'll give mitigating circumstances instruction. I think.
I don't know what the defense is asking for, so I just left them all in there.
All right. Is the defense seeking any on any of the statutory mitigating circumstances?
Yes, Judge. Oh, we have a number.
I'm sorry?
7 and 8.
Okay. State have any objections to 7 and 8?
No, sir. Just for the record, I will number age of the defendant as number 1 and any other factor as 2.
Okay. Defense have any objection to that, to those being designated 1 and 2?
No, I do not, Judge, but co-counsel is questioning them.
Okay.
I get what you're saying. All right, so I think both sides agree that the age of the defendant at the time of the crime will be designated in paragraph 1, and the existence of any other factors in the defendant's character, background, or life, or the circumstance of the offense that would mitigate against the imposition of death penalty be designated in paragraph 2. Yes, sir.
Defense agree to that?
Yes, sir.
I anticipate reading victim impact evidence, as there was some of that testimony presented. State have any objection to that being read?
No, sir.
Defense?
No, Your Honor.
I'll read recommended sentence. State have any objection to that being read?
No, Your Honor.
Defense?
No, Your Honor.
All right, I'm going to need a verdict form, of course.
I think, just looking through some old cases, I've got a standard.
I think I've got a form up here.
Here it is. I got it. Yeah, this is a good one. What's the case? 56. 2013. CF. 608. 8. Sorry, I should have done this earlier. I apologize.
Sorry.
All right, courtroom 3. Crap. Did Alice get that email?
She did.
She did? What did you say the email address is again?
crumpa@circuit19.org. She may have left. If you don't mind. I'm not sure she's back there.
Judge, when you say it's available, can we address the doubling instruction?
Yeah, just a minute.
She's still here, Your Honor.
Oh, she is?
I told her it was coming.
Okay.
Okay, should be coming.
Okay. It is. If you can print it there.
Oh, here's, yeah. I know. I know. Okay.
Let me just look at the verdict form, or recommendation form. Okay, bring it to me. Yvonne, can you hand this to one to the defense and got one more? Hand it to the defense. I'll print one for the state here just a second.
Oh, I'm not.
There's a copy of both sides of the verdict, or the advisory sentence form, I should say. Defense have any objections to the form?
No objection, Your Honor.
Okay. What did y'all want to comment on the doubling instruction?
It's in the instruction, Judge, the way that I see it in our papers that we were relying on for the instructions. However, I don't know when it's appropriate for us to make argument as to it, or do we just leave it in there and argue it to the jury? Because I don't know how it comes into play for them. It's more of a legal matter for you to make a decision whether or not they're actually double. I don't know if that makes sense to you or not.
No, it makes sense, but I think it's necessary for the court to instruct them on how they consider one or more aggravating circumstances that may emerge.
Okay.
Let me look at the standard instruction.
And I was going to potentially do like a JOA argument in reference to it to have them not even go back to the jury based on the doubling, but the way the instructions read, it appears to me that we just make our arguments in front of the jury when we do our closing arguments, and then...
Well, yeah, I understand what you're saying. I think that illustrates ring issues and other issues. That is, under the Florida scheme, the jury's not obligated to disclose which aggravating factors, if any, they found beyond a reasonable
Right.
doubt. Other states require them to do that. So.
Okay.
But two of the aggravating factors have been found by the jury beyond a reasonable doubt, so we're bulletproof from ring, and we're bulletproof from the case in front of the Supreme
Right.
Court now.
All I'm saying is under Florida law, they're not obligated to disclose which
Right.
ones they find beyond a reasonable doubt or not. Okay. All right. If you want to send the corrected ones back here to Miss Alice, I can print them up. I'll print a copy for the court, which I'll give to the jury, and then one for the state and defense. Now, do y'all want, I'm just asking, do y'all want extra copies provided to the jury like we did with the guilt phase?
Yes, Judge.
Okay. How many do y'all want, do y'all wish to provide them?
Two. We would ask for each juror to get a copy. Since
Okay.
this is an individual decision that each one of them is making.
I'm happy to do it. I mean, I used to do it in the guilt phase too, but I'll have 12 copies printed, one for each juror. And you. What am I up to, 13? Okay. All right, now, the only other thing is, prior to y'all giving closing argument, I'll just kind of modify the closing argument instruction and just advise them that the attorneys now will present their closing arguments. What the attorney says is not evidence. That the state has the opportunity to address y'all first, followed by the defense. And that's it.